Who is in charge of your children? That's become a perennial question that has grown in importance over the last few years. Now, when I was a child, it was understood that, with rare exceptions, parents were in charge of a child's upbringing. This included medical, religious, and educational decisions. Over the last few decades, though, the role of the parent in these decisions has been replaced by experts. What happens when the goal of the experts differs from those of the parents? Who decides the future of the rising generation? It was understood that the state acted in loco parentis, in place of the parents, only for the safety of the child. A recent case in U.S. District Court shows that it can also be health departments, child services, schools, or even courts. Government not only believes they know better than the parents, but are more than willing to act in loco parentis Tyrannis. So we'll discuss that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. We teach that rising generation to be free. It's a very important part of what we do. It's why this case caught my attention, because again, you're dealing with courts and government interfering with the raising of our children. And well, if we don't teach the rising generation to be free, we can't really be surprised when they become serfs, servants, subjects, even slaves. I've got some news regarding the website that I'll talk a bit more at the end of this episode. But for now, let's take a look at this case involving what's best for the child. Who decides what is best for your child? Well, this is a fundamental question and is often referred to as parental rights. For most of human history, the answer was simple and straightforward. The parents decide. With the advent of government, opportunities were created for state intervention in parental rights, but they were limited to protecting the safety of the child. Of course, it didn't take long for Lord Acton's warning to enter the picture. Power tends to corrupt, and absolute power corrupts absolutely. We've probably all heard the stories about some overeager child protective services, or their counterparts, taking children away from parents for the flimsiest of reasons. Sometimes all it took for CPS to get involved is for a neighbor who didn't like the decisions the parents have made to file a complaint. Didn't take long before schools were to get involved as well. There's a saying I've heard often enough: bad facts make bad laws. Put another way, when you write general laws based on the exception rather than the rule, the often unintended consequences can be catastrophic. For example, many states and localities, in an attempt to protect children from abuse, empowered faculty and staff at schools to report incidents of suspected child abuse. Rare but terrible incidents of abuse not only morph the ability to report into a duty to report, but also change the standard of reporting from evidence of physical abuse to suspicion of mental abuse. The problem is twofold. First, mental abuse is not well defined, and second, suspicion is not necessarily based on anything real. This has led to an attitude that the schools are ultimately responsible for the physical and mental welfare of a child, including determining what they need for an education. Now, whereas school boards used to work with parents and parental groups to determine educational standards, today they are being decided by experts, completely devoid of parental involvement, and with little, if any, concern for the individual needs of the child. A recent case out of the U.S. District Court of Maryland seems to be a perfect example. The premise of this case is fairly simple. In this lawsuit, parents whose elementary-age children attend Montgomery County Public Schools, MCPS, seek the ability to opt their children out of reading and discussion of books with lesbian, gay, bisexual, transgender, and queer characters because the book's messages contradict their sincerely held religious beliefs about marriage, human sexuality, and gender. The Montgomery Public Schools, MCPS, was using material in the classroom that several parents found objectionable. In this case, the objections revolved around the parents' religious belief and the faith they wish to instill in their children. Now, why did these parents feel the need to sue MCPS in federal court? Because their right to opt their children out of offensive material was being denied by MCPS. Last school year, MCPS incorporated into its English language arts curriculum a collection of storybooks featuring LGBTQ characters, the storybooks or books, in an effort to reflect the diversity of the school community. Initially, parents could opt their children out of reading and instruction involving the books, as they could with other parts of the curriculum. In March of this year, the defendants, the Montgomery County Board of Education, the MCPS superintendent, and the elected board members, collectively the school board, announced that parents no longer would receive advance notice of when the storybooks would be read or be able to opt their children out. When MCPS initially incorporated into their curriculum material of a sexual nature, the parents could opt their children out. Then in March of this year, the leadership decided, you know what? The material they wish to expose to children attending their schools was more important than the concerns of the parents and their religious instruction. Now, ironically, the attempt by MCPS to reflect diversity denied the diverse ideas of those parents. This action led to some concerned parents filing the lawsuit. Following the announcement, 3 families of diverse faiths filed suit against the school board, claiming the no opt-out policy violates their and their children's free exercise and free speech rights under the First Amendment, the parents' substantive due process rights under the 14th Amendment, and Maryland law. The plaintiffs contend state law requires MCPS to provide opt-outs for the storybooks because, in their view, the books concern family life and human sexuality. The school board's position is that the storybooks are part of its English language arts curriculum, and opt-outs are required only for the family life and human sexuality unit of instruction, a separate curriculum. As part of the suit, in order to protect their children from the exposure to and potential damage from these books, the parents requested a preliminary injunction against MCPS to prevent them from implementing the no opt-out policy. Most states recognize, at least on paper, that parents ultimately have the power to control the education of their children. For this reason, states that require education in sensitive areas have laws allowing parents to opt their children out of that specific instruction from the case. Like most other states that require or permit instruction on human sexuality in public schools, Maryland allows for opt-outs from such instruction in certain circumstances and requires schools to adopt policies, guidelines, and/or procedures for student opt-out and to provide alternative learning activities. I say that states recognize parental rights on paper because these laws mean nothing if they are not logically enforced. By that I mean that the laws allow parents to opt their children out of instruction they find objectionable, even over the objections of the school or district. The Associate Superintendent for Curriculum and Instruction Programs at MCPS, Nikki T. Hazel, said, "The new opt-out policy was the result of meetings with a small group of principals in March 2023. During which the school board determined that principals and teachers could not accommodate the growing number of opt-out requests without causing significant disruptions to the classroom environment and undermining MCPS's educational mission. Sadly, this is a sentiment I have heard all too frequently before. From politicians to bureaucrats, and yes, even school boards and principals, it seems more often than not these groups would rather force others to comply with their failure rather than learn from it themselves. The school board for MCPS found that a lot of parents were opting their children out of the classes with these objectionable books. Rather than asking themselves, hey, if so many parents object, do we need to look again at these books we've chosen? Instead, their response is to prevent parents from opting their children out. The school board had 3 concerns. First, high student absenteeism. In one instance, for example, parents sought to excuse dozens of students in a single elementary school from instruction. Second, the infeasibility of managing numerous opt-outs. Teachers would have to track and accommodate opt-out requests for their students, and other staff who spent time in multiple classrooms would have to do so across an entire school. Finally, the school board was concerned that permitting some students to leave the classroom whenever books featuring LGBTQ characters were used would expose students who believed the books represented them and their families to social stigma and isolation. The school board believes that would defeat its effort to ensure a classroom environment that is safe and conducive to learning for all students, and would risk putting MCPS out of compliance with state and federal non-discrimination laws. Based on these concerns, the school board decided to disallow opt-outs for the storybooks, regardless of the reason, after the 2022-2023 school year. Did you see that? The school board was more concerned about their lives than those of the children. They were concerned with high student absenteeism, but not why the students were absent. They were concerned about the workload of the teachers, but not the impact on the students. And finally, while claiming they were concerned about the social stigma of students who believe the books represent them, the board showed absolutely no concern for the significant number of students who might be uncomfortable, even stigmatized, by being exposed to such topics at their age. Now, my heart breaks to see people who have such a wonderful grievance receive unconstitutional advice from their legal counsel. The plaintiffs claim the school board's decision to disallow opt-outs from their storybooks likely violates their rights under the Free Exercise Clause of the First Amendment and Due Process Clause of the 14th Amendment. The school board argues the plaintiffs have not established a likely constitutional violation. The plaintiffs claim that the school board's policy violates the Free Exercise Clause of the First Amendment. Now, faithful watchers and listeners of the Constitution Study probably know what I'm going to say next. This cannot be a violation of the First Amendment to the Constitution of the United States, since the first 5 words of that amendment are, Congress shall make no law. Congress had nothing to do with this policy, so it cannot be a violation of the First Amendment. Furthermore, even if this case violated the First Amendment, it plainly is not a violation of the Free Exercise Clause. However, according to the plaintiff's attorney, the First Amendment, applicable to the states through the 14th Amendment, provides in part that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. The Free Exercise Clause protects against laws that discriminate against or among religious beliefs or that restrict certain practices because of their religious conduct. To violate the Free Exercise Clause, a law, regulation, or government policy must burden religious exercise. The fact that a government school is teaching something that does not comport with your religious beliefs does not prevent you from exercising your religion. It does not even prevent a parent from teaching their children that the instruction they receive from the government school is wrong because it is contrary to their belief. What we have here is not a violation of the plaintiff's free exercise right, but an establishment of religion. By claiming the plaintiff's religious beliefs are superseded by the state's beliefs about diversity and sexuality, the MCPS school board has effectively established a tenet of faith that all public school children must adopt. While this case is not a violation of the First Amendment of the Constitution of the United States, it is a violation of Article 36 of the Declaration of Rights in Maryland's Constitution. No person ought by any law to be molested in his person or estate on account of his religious persuasion or profession or for his religious practice. By forcing children to be taught a form of belief contrary to their parents' desire, they are molesting both the parents and the children for their profession of their faith. As noted before, plaintiffs also claim MCPS's policy violate their rights protected under the Due Process Clause of the 14th Amendment. The plaintiffs assert that the school board's refusal to allow parents to opt their children out of reading and discussion of the storybooks infringes their right to direct their children's upbringing in violation of the Due Process Clause of the 14th Amendment. They claim this due process right is fundamental, triggering strict scrutiny. Now, what is the Due Process Clause of the 14th Amendment? Nor shall any state deprive any person of life, liberty, or property without due process of law. So does the school board's policy violate this right? The Supreme Court has stated consistently that parents have a liberty interest protected by the 14th Amendment in directing their children's schooling. When the parent's interest includes a religious element, however, the court has declared with equal consistency that reasonable regulation by the state is permissible even if it conflicts with that interest. That is the language of rational basis scrutiny. Once again, we see courts placing their opinion above the supreme law of the land. The Supreme Court recognizes that parents have a liberty interest in directing their children's schooling, but then they add a religious exception that does not exist in the text of the Constitution. The court is effectively saying you have a right to due process unless there's a religious element. In fact, it's the Supreme Court that's prohibiting the free exercise of religion by creating a religious test for due process. So where does that leave our plaintiff and their request for a preliminary injunction? The plaintiffs have not established a requirement for a preliminary injunction. The motion is denied. Their request for an injunction pending appeal is denied. A separate order follows. In other words, no injunction for you. I can understand the First Amendment argument against the injunction, but not the 14th Amendment one. Yes, the court states that the Supreme Court has placed a religious exemption on the parent's liberty to direct their child's education. But the judge took an oath to support the Constitution of the United States, not the opinions of judges. Which brings me back to my opening question. Who ultimately guides the education of your children? If the schools, with the support of the courts, are able to take their role as in loco parentis and use it for whatever agenda they decide, then their actions are tyrannical indeed. So there you have it. These parents who simply want to protect their children from sexual ideas that they don't think they're ready for or that violate their religious beliefs is denied because a court basically said, if it's religious, you don't get due process. That's what we're stuck with. Seems to me we need to pick some better judges, some better justices, or at least pick people who will appoint better justices at the federal level. I don't know where this case goes from here. I hope it still proceeds. I hope somebody will look at this rationally and say, wait a second, how can you say you have due process if we're going to deny it simply because it's religious? If it does get to the Supreme Court, it's going to take a while. But I want you to be aware of it because this is another example of you can't depend on the courts to protect your rights because they worry more about the opinion of other judges than they do the supreme law of the land. Now, if you want the links that I use for this, well, you'll find the article on the website, constitutionstudy.com. As I mentioned, it's had a recent update. I've done a major overhaul of the site. Not only do you have the articles and videos that I work on here, but there's a whole section dedicated to news. The news articles I find interesting now get posted to the site automatically. You can also find the radio programs that I also produce on America Out Loud Talk Radio. When they go to the web, you can find them there on the website as well. Of course, we still have the mailing list. We still have the Ask a Question, and there'll be more features showing up soon. I'm trying to get the boot camp and the Patriots program up and running in time for Constitution Day, which is coming up pretty quickly. It's September 17th. So please head to the website, constitutionstudy.com, and find out more. If you can support the work that we're doing, please do. Just go to the store, you'll find a donation option. I'm working to add some more features to that as well. But whether it's a one-time donation or a monthly donation, everything you can do to help would really make a difference because right now all of this comes out of my own pocket. Of course, you can also share this information. I want other people to know about the Constitution Study. And I'd also love your feedback about the new website design. Like it, hate it, like to see something else in there, please let me know. Most of all, I hope you come back and join us here next time for the Constitution Study.